just kind of tell you who we are and what we do, and then give you kind of an overview of the different legal issues that we've been dealing with during the COVID crisis. And then Paul's going to dive deep into more kind of the employer-employee situations that arise on a day-to-day basis during these times. So Sneed, Vine & Perry is our law firm. Sneed, Vine & Perry has been around since 1926. We're the oldest law firm in Central Texas. We've had a Georgetown office since about 30 years. And there are 6 attorneys here in Georgetown. And we have a pretty varied practice, everything from commercial litigation to real estate banking, and just generally serving as kind of outside counsel to the small and medium-sized businesses in this community. And so our clientele has, as all of us, has been deeply impacted by this COVID situation. And some of the issues that we've had to deal with, day one, we started having to deal with, whether or not our clients could actually be open for business, as I'm sure many of you struggled with, whether you fit into definitions of what an essential business was or an essential service. And I will tell you that, living where we do in Central Texas and having, one set of rules in Austin and Travis County and one set of rules in Williamson County and Georgetown, we had clients scrambling to figure, whether they could even have the doors open. Other issues that we've dealt with are, during these difficult economic times, folks dealing with their bank, their lenders on loans that they have outstanding, landlords and tenants trying to figure out how to navigate these times and working out different arrangements. Spent a lot of time doing that. And then there's a phrase that I'm sure most of you have gotten to learn during this crisis called force majeure. And that's a provision that is in lots of contracts that talks about acts of God. To be real honest, a lot of lawyers have kind of just glossed over that phrase or that paragraph in the contracts and assume that, well, none of that stuff is actually going to apply. We're never going to have, an act of war or anything like that in the United States. Well, that clause of most contracts is going to be one of the most heavily litigated clauses probably in the history of our legal system throughout this crisis, because, does your contract allow you to terminate it because the government says you're no longer open for business? Well, we're about to find out. So those are the types of things we've been dealing with on a day-to-day basis. But what really kind of prompted this Power Hour meeting is what a lot of you folks have been dealing with, and that's how to deal with employees and sick leave and those types of issues through the crisis. Paul has a lot of experience advising employers and employees in labor relations. So I'm going to turn it over to Paul and let him kind of walk you through the details of this.
Good morning to everybody. I'll start out by saying that I will do my best not to guess, but some of the things we're talking about are best practices, and obviously some of the rules and recommendations are changing daily. So we've got moving targets on most of this. I'll also say when I'm talking, the rules are different for different types of employers. So when I'm talking, because I think it's probably the vast majority of people that we have listening here this morning, unless I say otherwise, I'm talking about a private employer, not a public employer. And I'm also talking about employers that have 50 or less employees, because the rules can be different if you have 50 or more employees. So if we've got some that fall into those other categories, I'll be glad to guess at your questions too. But I just want to kind of make that note up front. And also another thing that's important to think about in the employment world, we've got exempt employees and we have non-exempt employees. And those are terms that are used under the Fair Labor Standards Act. And it doesn't matter what we label those employees, though a lot of employers simply like to label them one or the other. Whether someone is exempt or non-exempt under the Fair Labor Standard Act depends on their job duties, entirely on their job duties. And so, and what we tend to think about for as exempt and non-exempt is hourly versus salaried employees. The law specifies, I mean, you can pay anyone salaried if you want to. It doesn't change the fact that they still may be an exempt or a non-exempt employee. So what I'm talking about is primarily non-exempt employees that are paid hourly. And so, because the rules can be different for somebody who's a salaried employee. And so one of the things that Josh and I have been talking about, we have not seen this yet, but I expect it's going to be coming. Understand that it is the employer's job, not the employee's job, to maintain accurate time records for the employee. Well, that's one thing. When everybody's working inside the office, we're in a different world now. So for you out there who have employees that are now working remotely, understand that it is still your job and your responsibility to have accurate time records. And the significance of that is we may have an employer and we may have employees truly down the road say, wait a second, during that whole pandemic, I was working 60 hours a week, 70 hours a week. How do you know? Because it's going to be your job as the employer to prove that that wasn't the case. And any time that the employee spends basically doing compensable work is time. The situation Josh and I had, you have a receptionist that's now working remotely. Well, there may not be 5 calls a day, but if that employee is expected to be available to answer the phone all day long, that's all compensable time. And so that's just kind of a word of warning that in this era where we're seeing a lot more people work remotely, don't forget it is still your job to maintain accurate time records. With that, we've had a few questions that have been punted to us along the way. And so I'll just try to quickly kind of go through the list of some of the questions that have been asked and go through there. One of them was, if an employee tests positive for COVID-19, I know I need to inform them, but do I also need to inform all my other employees? Do they need to go home and be quarantined? Related, does all the employees then need to be tested? And then the follow-up question is, do we then have to shut down? Well, one of the things I found confusing about the question initially, I don't know why the employer would be the first to find out that the employee has tested positive. As far as I know, it's the employees that are getting the test results. But if you do have an employee to test positive, certainly that's important information. That is information that does need to be shared with the other employees, but not the identity of the person who tested positive. We still have all the confidentiality rules that apply for medical records. And so the fact that someone tested positive is an important bit of information that needs to be shared. The suggestion from CDC and everyone else is that we then go about trying to identify everyone that employee had close personal contact with. Those employees, the suggestion is that those employees then be the 14-day quarantine if they're not showing any exceptions, but there is no requirement to shut down. There is no requirement that then those other employees automatically be sent home. And if it's in a situation where everyone is exercising, social distancing, all the things that have been recommended, that there's no requirement that anyone be sent home other than the employee who's tested positive.
Hey, Paul, can I jump in? I'm going to ask Paul a question for y'all. I'm sure that a lot of y'all are in a situation where if one of your employees tested positive and you needed to, notify your other employees, it would be very difficult to do that in a generic enough way that, everybody in the room wouldn't know exactly who you're talking about. generally speaking, one of the things under the Privacy Act that folks are very wary of is inadvertently revealing medical information through, you know, maybe you didn't say the person's name, but you said the guy that sits at that desk, you know, tested positive. Well, that's the same thing as identifying them. And so there's no question that there's going to be times when you've got to walk a really fine line between providing the proper amount of information to the other employees and not revealing the positive testing employee's identification to anyone. So any advice you can give on that, Paul, other than to be careful?
Well, you know, it's one of those situations, if you work in a 5-man shop,
Right.
we tell everyone someone has tested positive and there's only 4 of you there. Well, you know, it's not too hard. I think, you know, to some degree, we just have to use a little common sense, and obviously some identities are going to be revealed, but you still don't need to be saying the names.
Okay.
Yeah, that's as good as you can do.
Paul and Josh, I just wanted to chime in. I think I'm glad y'all clarified that point, because we've heard from many of our small members that that's the case. They might be, hey guys, one of our employees has tested positive for COVID. And so we just want to let you know that. In other unrelated news, ex-employee will also be working remotely for 2 weeks. You know, there's got to be that common sense where it's noticeable that person X is not there, but with the information coming out there. So I'll say personally, I appreciate y'all clarifying that point a little bit, Paul and Josh. So
Sure. One of the other related questions we've had is, if I have an employee that tests positive, who am I obligated to inform? Do I need to inform the media? Do I have to inform customers? Who do I have to tell? Again, somewhat best recommendations. If there is any possibility that the transmission occurred at work, first and foremost, notify your workers' comp insurance carrier. If it has even the remotest possibility of being deemed a work-related event. There is also some requirements to notify OSHA, since you are obligated to keep a safe workplace. Now, what I have read, and I certainly don't, I don't peruse OSHA rules daily by any stretch of the imagination, thank goodness. But on the OSHA requirement, as I have understood the guidelines thus far, if it is someone who is fairly asymptomatic, does not require hospitalization, those kinds of things, there's really, you can basically treat it like you do the flu. But if you have someone that is seriously ill, then there are some requirements to report to OSHA. So out of safety standpoint, I think notifying your workers' comp carrier and OSHA are the two things. But other than that, there are no real requirements of reporting to anyone. Obviously, one of the questions we are getting frequently from a standpoint is, who do I have to keep on paying? If we've got employees that want to work remotely, but their job doesn't really fit working remotely, if we have employees who have tested positive for COVID-19, if we have employees who are concerned about the exposure, who don't want to return to work, kind of the whole gamut of questions there. Who do I have to pay? This is one of those times that it's important to distinguish between exempt and non-exempt employees. So my answer is related to those hourly employees. Under just basic law, you are not required to pay anyone that isn't working. Now, you may have paid time off provisions and policies. You need to adhere to those. If you have 50 or more employees, there's things such as the Fair Labor, the Family Medical Leave Act that can come into play. We've got additional emergency measures that have come into play strictly through COVID. But as a general rule, though, the employer is not required to pay someone who isn't working beyond what the employer provides through PTO. And so from just a general basic rule, that is it. Now, there can be some areas where that gets a little gray. And I suspect most of you are familiar with this law we have called the ADA, the Americans with Disabilities Act. Having COVID-19 does not qualify as a disability. It's an illness, it's not a disability. So a COVID-19 test result positive doesn't all of a sudden put someone into the area of being disabled. The question that's a little more difficult to answer is, I haven't got a positive COVID-19 test result, but I've got all these other disabilities that are part of who I am that make me more at risk than the general population. Do I then, as an employer, have a duty to try to accommodate that person's disability to mitigate their risk? And in that situation, I would say, yeah, I think the employer probably does. We've got an employee with a disability. I think we then do have a duty under the ADA to mitigate, and that may mean maybe some accommodations to allow that employee to work remotely. But
yeah, Paul, let me jump in. One other kind of issue that Paul can shed some light on is, let's say you've got an employee who has, tested positive for COVID, or is maybe, is quarantining under good advice because they were around someone who tested positive for COVID, and they are working remotely, even if they have full-blown COVID. If they're working remotely, then you still got to pay them. And so they're not, you're not allowed to stop paying them just because they're working remotely and they have COVID. Is that correct?
correct.
Okay.
Correct. If they're working, they're working.
Guys, quick question that came in on the chat on this topic. If you don't mind me chiming in, it's if a coworker, if you have an employee that tests positive and a coworker refused to come into work, even if the coworker was not in contact with the employee. So basically, if Josh, you had COVID and Paul says he's refusing to come into work, even though he never came in contact with you, Josh, is the person saying what they did was they actually required them to use PTO if they weren't working from home and didn't want to come to work. They did not choose to pay them because it was an employee's choice. Did they take the appropriate action or any recommendations?
No, I think that is the appropriate action. Well, I said it's kind of what we were talking about earlier. I mean, from the standpoint that PTO needs to be utilized when that is available. But there is no law, there is no rule, there's no requirement right now that I accommodate anyone's preference to work remotely.
Or fear of COVID.
Yeah, and so just because someone is concerned they may be exposed, they're concerned that they are at risk, no, I'm under no obligation to accommodate their concern. And if that employee refuses me, if I don't want that employee to work remotely, if I've got a problem with that, and the employee refuses to return to work, perfectly within my right to terminate that employee. Now, also understand as the employer in that situation, we are now supposed to report that to the Workforce Commission. If we have an employee that refuses to return to work due to COVID-19 concerns, we're to report that to the Workforce Commission, and that employee may still be eligible for unemployment benefits. If they have legitimate reasons why they believe they shouldn't return to work, they are perfectly capable of explaining those reasons to the Workforce Commission. And so you're basically offering them to return to work or demand that they return to work doesn't necessarily negate their rights to unemployment benefits. Now, as far as I know, it has not been addressed how those unemployment benefit claims will be attached back to the employer. We don't know if that's going to be allocated back to the employer or not.
And a kind of the corollary to that is if you have a policy that says hey, you know, you were in contact with someone that has COVID. Employer is requiring that all employees quarantine for 14 days. And as Paul said, you can do that. And if they're hourly, you don't have to pay them if they're not working, but they may be eligible for partial unemployment benefits for that period that you are not allowing them to work. You know, and that's an area that, to be real frank, I don't think that we have a whole lot of guidance on how the Workforce Commission is going to treat that, especially when, you know, you're following the governor's orders and telling them to stay home. Have you terminated that employee without cause under the Workforce Commission's definition?
Yeah, and guys, a question that came in, well, I mean, similar to I think what Paul you mentioned about, you know, ADA and COVID not. What if they are over a certain age? Does that come into play? So like the question is, what if the employee is over 70 years of age and just afraid to come into work? Is there any requirement on there? Does that change anything with age or?
Age is not a disability.
Okay.
I disagree with that.
So I'm beginning to think it should be. No, but age isn't a disability. So
Okay.
would not be covered under the ADA, but it certainly may fall back into, you know, that situation. And, you know, like I said, if it's a situation where we're, okay, let me back up for a second through all of this and just take one big step back. We have what is called Title VII. And Title VII is the federal rule, and there's a state complementary law as well that outlines all of the typical things that we think about being discriminatory measures. You know, we can't discriminate in employment due to age, race, sex, national origin, those kinds of things, okay? And so if you're an employer who has 15 or more employees, you're covered by Title VII. And so while we're talking about all these things we can do and can't do, obviously, Josh and I are both Baptists. If you come up with a rule that says everybody can work remotely but the Baptists, because we know you're going to stay home drinking, you know, I mean, okay, now we've got a rule that's not really related to COVID that is still illegal because of a different reason. And so when we're implementing these rules and saying who gets to stay home, who doesn't, who has to come to work, who are we terminating for not reporting to work, those types of things, it's still, you need to remain mindful that you still can't discriminate against your employees based on age, race, sex, national origin, those kinds of things. So be sure you're administering your policies, I would say not necessarily equally across the board, but at least fairly across the board. You know, I don't think there's anything wrong with saying we're going to favor elderly employees. We know you're at a higher risk. If you're an elderly employee, we're going to allow you to work remotely, but we're not our younger employees. I think that's fine, but the inverse is not true. We can't say we're going to require all of our older workers to be in the office working, but our younger people are more familiar with technology, y'all can work remotely, because under the age discrimination, the protected class is those over 40. And so then we are, you know, discriminating against older people. So with kind of that caveat, that was kind of a long roundabout answer.
No, thanks, Paul. I appreciate it. I'll let you, I know you had some pre-questions and I'll come back. And I think one of the questions we got, we can ask in a little bit, but I didn't know, we kind of got.
I've got one more, Jim, an area that I'd like Paul to take a shot at. And that's that I'm sure a lot of folks are dealing with is, so these are kind of your rules for how to deal with your employees, but what do we do when we start talking about, you know, whether it's a retail place dealing with customers, or whether it's, you know, businesses who have, you know, subcontractors working for them, or their subcontractors working for somebody else. What can we do in terms of, you know, right now, You walk into a restaurant or retail place and they ask you a bunch of very personal health questions and they take your temperature, which is, health information, is that allowed? I mean, I know it's recommended by a lot of folks, but how does that work? Or can we demand that someone who's contracting with us as a subcontractor, independent contractor, that they reveal a bunch of, private health information before we let them work for us? So Paul, you would, I know there's a difficult to take a shot at it.
Big broad question there. Like I said, I think we're pushing a line, we're pushing a limit. As long as we're talking about, have you had any close contact with someone who's been tested positive? Have you traveled out of the country? Those type of fairly benign questions, have you tested positive? I think we're safe. By and large, now because of the governor's rule, we do have kind of a minimum standard. But if an employer or a place of business wants to go above what's going to set the minimum standard, if I want to require not only must everybody who walks through my door have on a face mask, you have to have on latex gloves and face coverings and your hazmat suit. I can do that. That's my right as an employer, owner of a place of business, from a restaurant, whatever. I can impose those kind of rules over and above what we have. I think the same thing if I'm working with with subcontractors to say, these are my rules. But by the same token, I think there is a limit to the amount of medical information we can start demanding of people.
Paul, Josh, for a minute. So, a lot of companies have modified their plans to all of a sudden say, before the governor's order to wear a mask, but certain things, is it recommended that they modify employee policies to reflect that? Or can that be, do they need to get that in the handbook? Or like if I made my employees wear latex gloves now, and if they don't, there's potential disciplinary action. Do you recommend updating policies and procedures or having that written, or any thoughts on that end?
I don't think we need a policy that says we're going to follow the law. Okay, so if our rule is we're going to obey the governor's order, I don't think there's a need to do anything. Now, if you're going to go over and above, then yeah, I think you need to have a policy, especially if you contemplate disciplinary action coming from that. Then certainly in a perfect world, you want to be able to demonstrate that information was clearly and concisely conveyed to all your employees, and they knew the rules before any disciplinary action was taken.
Yeah, and this is something that we've discussed a bunch, and generally speaking, I think Paul's, telling your employees to comply with the law is not something you necessarily have to codify in a policy. Hey, we don't allow stealing in our business. It's not something you have to put into a manual before you can enforce. And with the ever-changing nature of, the governor's orders, the CDC orders, it would be pretty difficult and pretty time-consuming to be constantly updating your employee manuals. Now, we're all reacting on a day-to-day basis as to what we're actually doing in our businesses, but then turning around and trying to codify that is probably not going to be, beneficial, and it does present the opportunity for you to be wrong and have the wrong policies in place when all the recommendations have shifted. And if you're not constantly updating, you can be wrong. Now, it does bring up a point as to what do you do when there's kind of conflicting provisions out there, and the mayor says this, the county judge says this, the governor says this, and the CDC says this. The general idea is you're always safest following the most strict requirement. But if you choose to do something other than the most strict requirement, you probably need to convey, or you do need to convey to your employees what the requirements are.
Thanks, Josh. Paul, keep going. I just remind everybody, if you have a question, you can send them in the chat feature and we'll push them along. So Paul, floor's yours.
One more quick area, then I'll just forfeit it all for question and answer. there's a lot of talk, a lot of concern for its employer and also potential liability for places of business. All unanswered questions. One of the reasons, there is a lot of talk about new legislation for immunity, but it kind of goes back to to have a cause of action. I've got to prove that you're approximate cause of my injury, and one of the biggest hurdles anyone is going to have in today's world, whether it's a customer or an employee, is proving that no, I got COVID-19 there. You're the person who exposed me. That's where I contracted it. It was in your place of business, whatever. Well, that's, I think, is going to be a very difficult hurdle for anyone to overcome. But that alone does not mean that as an employer or place of business that you will spend a lot of money paying someone like me or Josh to defend you in that claim until someone gets the idea that that's a really hard hurdle for them to clear. So with that, I think we do need to be using caution from the standpoint, like one of the questions we got, like, if I have an employee that tests positive, in a business environment, do I need to have my facilities professionally cleaned? No, but why wouldn't you? From the standpoint that you can demonstrate, here are the actions we took to mitigate the risk, the harm to everyone else, whether it's to the other employees, to customers, to clients, to whomever it is. I think those are prudent things to do. Now, I understand that's also probably is a limitless list of things we could do, but I think we do want to be in a position where we can demonstrate we took some reasonable preventative actions once we have reason to know that we might have someone in our facility under our employ, under our control, that has the potential to be spreading the disease to others. So with that, I'll open it up for questions.
Yeah, great point there, Paul. And I think that's probably one of the biggest questions that a lot of businesses have right now is that, yes, it might not be, it's going to be difficult to prove that it didn't take place at your business, but it might cost you a lot of money to defend your case and keep you from paying for that in a long period of time. One question that came up, guys, and with schools being held maybe online, and I think you kind of touched on this, but I'll be specific. And you have employees that are remote. Is there any requirement of the employer to still pay full wages if they understand that the employee is not working the full hours because they are now becoming, educating their kids at home? I think we've already covered that, but I just want to make sure that you haven't seen any educational provisions for an employee in that area.
I'll try to address, if you have 50 or more employees, the rules change. There are provisions under the emergency medical family. I can't keep the names straight anymore. That specifically deal with the lack of availability of childcare and/or the lack of availability of school. I have not read either one of those to provide, I have chosen now to homeschool my children, or I have chosen now to keep my children out of daycare. I think it is on them legally, truly not being available before that leave is triggered. But taking that away, again, kind of the distinction being made between, are we talking about an employee that is an exempt employee or an employee that is non-exempt? If we're talking about a non-exempt employee who's paid hourly, then of course their compensation is affected. If they're not working as many hours as they were, they're not working 40-hour weeks anymore, then yes, you don't have to pay them but for the hours they work. Now, let's also be in mind that if they're the hourly employee and now working 60 hours a week, you need to pay them for that too, at everything over 40 at time and a half, or one point in time, or someday they may be knocking on your door and saying, oh, those 60 hours a week, that 20 hours overtime that I get paid for, multiply that times 1.5 to get the amount you should have been paying me. Oh, and by the way, put it times 3 by it now because I've got a claim against you.
Wow. Real quick to clarify, if folks are subject to FMLA and they are required to provide leave, does that necessarily mean that they're also required to pay compensation for that leave, or those distinct requirements?
Now you're going to give me the line, because I know under the new rules, there is a fairly complicated list of what triggers it. In some situations, if you are under the FMLA, that now there is a period of paid leave, and then there's a period of 2/3 paid leave. And so if you're over 50 or more employees, it gets a lot trickier. Under 50, the answer's a lot easier.
So back earlier, Paul, we were talking about, the questions that businesses ask when people arrive, like have you come in contact, they check your temperature. One of the people said that they're actually requiring the guests to complete a form with those questions. So please initial that you have it coming, like they're getting some written records, it sounds like, on that. One, is that legal? And if it is there any recommendations, they didn't ask this, but for record keeping on that document, because now you have a printed copy with quote unquote medical information.
I don't think it's inherently illegal. I don't think we're getting into HIPAA violations just with asking those questions. But I think we do have a very high level of confidentiality associated with that by gathering that documentation. And my bigger concern would be is, what if a yes answer get past the checkpoint? We're asking these questions hoping to get no, I haven't traveled, I haven't been in contact. But my bigger concern is if you're requesting that information and you're getting it in writing, I think you need to put a lot of effort into making sure that you're doing that you're paying a whole lot of attention to the information that is applied. And when you get a yes, you're doing something very differently. I don't want you taking that information and just putting it in a pile.
Okay, good point. One of the questions that I had, unrelated to COVID, but Josh, you mentioned early on that force majeure is going to be one of the hot, items that's going to be talked about in courts. In my experience with contracts, there's a lot of times you might see civil unrest as an area in there. And, do you feel like that with, if you're a bit, as Steve Perry located on the square, if some of those protests potentially would have been longer, not trying to get into the, do you feel like, can you touch base on when businesses could see that portion maybe executed on a contract and, not really in Georgetown, but some of the other areas they've seen that shut down due to that potentially? Sure.
And there's a couple points to lead with. There's some kind of common law, existing law in the state of Texas that applies regardless of what your document says. There's clauses that prevent you from being required to fulfill your obligations under a contract where it's an impossibility. And sometimes that impossibility is defined by, as we say, 12 people who weren't smart enough to get out of jury duty. But generally speaking, it's always going to come down to the exact language in the contract. You're correct that civil unrest is a clause that occurs in a lot of those force majeure clauses, and whether the protests themselves, if you were had a downtown business in Portland, Oregon, it'd be pretty difficult to say that, your restaurant could be open tonight, when everything's on fire around it. You'd have a pretty good argument that if your lease said you don't have to pay rent during a period of civil unrest, and, they have decided that, some governmental authority said, hey, nobody go down to this area tonight. There's protests going on. You have a pretty good argument that you don't have to pay your rent. As you probably saw with all of the back and forths between, city, county, state, federal, where they were officially shutting down businesses, one of the in the background arguments that was going on was, whether or not they were going to trigger a lot of these force majeure clauses. The governor highly recommending that your restaurant not be open probably is not going to trigger it. The governor saying ye shall not be open probably is going to trigger it. And so there, in our world, a lot of what I was dealing with was a lot of huge commercial construction projects going on that all have these clauses, and you literally had billions and billions of dollars that were, one party was going to bear the weight of that, depending on whether or not, the construction project was officially shut down. And in Austin and Travis County, they kept attempting to shut down these projects. The most high profile of which was the soccer stadium. And the feds and the governor kept reopening them, which led to this kind of, limbo that the contractors and the owners were faced with. Hey, are we officially shut down or not? Because if we're officially shut down, I got to send notices to all these people. There's all these steps I got to take. And so all of that was a result of these force majeure clauses. What I would tell folks is, if they've got a contract, they need to pull out that contract, and that little paragraph that's, the second to the last paragraph in the contract is all of a sudden really, really important.
Jim, if I may kind of tack on to that, I promise you going forward, force majeure clauses will be much better drafted than they have been in the past. And like Josh, I have reviewed more force majeure clauses in the past, since March, than I have in prior years in my years of practice. So, but for example, I represent a youth organization. They were supposed to have a convention in the Metroplex earlier this month, where they anticipated about 14,000 people being there, probably 10,000 of those being students. And the biggest question was, well, what date matters? I mean, honestly, we can't wait last minute to decide we're going to pivot. And so if we cancel the contract, say July 1, but by July 12th, everything is lifted, are we now hammered because the rules weren't in place the day the convention was actually supposed to take place? I've not seen any force majeure clauses that deal with what is the applicable time. On some things, we're preparing, if we have to have a lead time to make decisions, I think those are some big unanswered questions.
I think on this call, we have people in the event industry, and I think that is something that is important to them is real, is they're hearing from brides or events that want to cancel for next spring already. Yep. And, we could be perfectly fine in the spring or very close in the spring, but without that language in there. And I think, as when we've done these power hours, we've had attorneys talk and our CPAs, it's like, this is why for business, it's important to hire and have a good trusted lawyer or attorney that can review things and be available for you guys on that.
You know, Jim, I hate to confess from in front of you and everyone else here, if y'all brought us a contract in the early part of 2020 or at some point in 2019 or before, I suspect Josh or I, either one, would have spent more than 2 seconds looking at the force majeure clause, because it never would have even possibly occurred to us that this is what we're talking about.
Yeah, and one thing that we found really interesting is now, you know, again, it's the clause that everybody's looking at in every contract. And, you know, most of the old force majeure clauses, there's no mention of pandemic, there's no mention of disease, illness, anything like that. It's basically talking about, you know, war and weather. Those are really the things that were, you know, that were discussed in those provisions to begin with. So now, I mean, we're literally talking about, you know, whether or not travel restrictions are in place from certain countries to this country. I mean, and it's absolutely very applicable. If your materials are coming from China, you know, the U.S. could be wide open, blown and going, everything fine. If China's not allowing exports because of you know, some virus, does that trigger your force majeure clause? So
it's a brave new world.
It really is, guys. We're wrapping up the power hour. I haven't seen, give anybody a last second to plug a question in to the chat feature, but I know everybody's already been taking advantage of that. I'll thank, as I stall just a little bit as somebody types, and I don't see anybody like waving at me that's on video to say I have a last minute question. Paul and Josh, thank you guys for being here today.
Jameson's got a very good question.
Yeah, so from what you've seen so far, have insurance contracts been paying to defend commercial named insurers even though infectious disease are not covered?
No, I have not seen that. And the other thing that I think took a lot of people by surprise is a lot of people have what's called business interruption insurance. Under most of those policies, matter of fact, I have not seen one yet, a business interruption policy where something such as this pandemic was not an excluded event. So I have not been seeing really any of the COVID-19 related issues being covered through insurance. Now, I think that may be changing from the standpoint if we get to where we've got employees saying, I contracted, you know, the disease at work, and I want to cover my workers' comp. From the standpoint, if we have customers that are suing us saying, I was exposed at your restaurant, perhaps we get that under general liability, commercial liability policies. But by and large, no, I've not seen any of the risks covered by insurance.
Yeah, I think that's Paul's last part there is the part that I think we're going to see a lot of fighting over, is whether your CGL, commercial general liability, covers any issues that, you know, someone, like it would a slip and fall, they're going to cover somebody claiming they got COVID. What is Jameson asking now?
He was asking about officer director policy, but I couldn't quite read it. What away.
I think he's asking, so with lawsuits, and there's quite a few nonprofits on the board, if let's say a local 501c6 organization that supports businesses was sued because somebody said they got COVID while hearing a presentation, would DNO, would the officers of and the directors of the organization be protected under a DNO policy, whether it's Rotary, the Chamber, CASA, you know, all these different organizations? If somebody came in, would DNO cover it? I mean, I think I don't, would DNO cover? What are y'all thoughts?
Okay, my answer may not be popular. DNO coverage provides you a defense. DNO coverage does not provide you with protection from liability over most of anything you can be sued for. Because if you're acting within the course and scope of your duties for the entity, then that's not really officer director liability. That's liability of the entity. And so the DNO policy should provide you with coverage of defense, but no, I do not think it's going to pay out a claim.
If a claim was proven and went that direction through COVID, which
Because you're active within the course and scope of your duties as an officer director of the organization. So there's no reason why you would have any personal liability in that matter.
And what I would tell you is in the same way that, you want a good attorney and accountant on your team, you want a really good insurance agent because, there's no such thing as a CGL policy. There's lots of different policies out there. There's lots of different endorsements you can buy back from exceptions. And you need to sit down with your insurance agent and have a good long talk about, what coverage you have now, what coverage you may need in the future. And they can walk you through all of those details. And just going, oh, I've got insurance, is worthless, because you need to know what that policy says and what it covers, and to make sure that you're, avoiding the risk properly.
Okay. Paul and Josh, again, thank you. One last thought, and maybe y'all can sum this up. A lot of these businesses have done SBA, EIDA loans and PPPs. They've been working with their banks on showing the records that they used it appropriately for forgiveness. Is there anything that you've seen from a legal document that would need to be touched on, or do you think the banks and, or God bless, or the Treasury have done a good job in making sure that that's pretty user-friendly? Or have y'all come across anything that closing that you would say, watch out businesses? That might be a whole nother conversation, but thought I'd just throw that one out there at the end.
Okay. We are not accustomed to having the federal government turn on a dime. It seldom, if ever, acts quickly. It usually takes months and most often years for it to do anything. The whole PPP and all the related programs actually occurred remarkably fast. When the federal government acts with such speed, it tends to be a faulty product, but it's the best that they could do at the time. There are a ton of unanswered questions. There are a ton of holes. And I think a lot of this will be sorted out over the coming months, but other than having phenomenally good documentation of where the money was spent. I mean, one of the questions we were asked whether we should segregate those funds or not. I advise my clients to segregate those funds. I know many others did not. But I mean, I think this is a situation where we just have to trust that no one changes their idea of what the purpose of the PPP and the other related programs was.
Yeah, and the one thing I'll say on that last thing is that, again, you hear these phrases, oh, I got a COVID loan. Well, there's many different types of loans and programs out there. All of them have different rules. And so one, you need to read your loan documents. And two, you need to read the corresponding federal regulations related to those loan documents, or have someone do that for you. One of the things that Paul and I were talking about yesterday that our clients are running into is with kind of the most recent round of loans that are not forgivable. They're just low interest, long-term loans. There's language in there that's very concerning for small businesses that prohibits you from making distributions to the owners, shareholders, members of the business outside of normal payroll. Now, as most of you guys probably know and understand, well, that's how most of our clients get paid. Is they may take some portion of their compensation in W-2 salary, but the goal is to take as much of it as possible through K-1 distributions. Well, that may be a problem if you are currently have one of these most recent loans you may not be able to do that. And you can understand kind of the logic behind it. The goal was to keep you afloat, not necessarily to make sure that you took home as much money as you took last year. And so it really depends on, you need to go through and read the loan agreement between your entity and the bank, and ask questions of your banker and possibly your legal counsel to determine what you can do if you're currently a borrower on one of those notes.
And Josh, you're referring to, and I think I'm correct. I see Ms. Brian asked a question. You're referring to some of the language in the SBA EIDL loans with that comment.
Yes, those are the ones that I've seen most recently.
Yeah, and for those who are curious, we actually it's on our YouTube channel. There was one with the U.S. Chamber of Commerce. They went into detail about that as well, saying, you know, there's some things with selling assets even that you can't, you know, because they're keeping you afloat on that end. So, wow, with 1 minute to spare, Paul and Josh, thank you so much for the virtual power hour today, guys. Again, as COVID has happened, the Chamber wants to, when there's timely information that we want to get out, and this has been something that our members have heard from us, keep your open for emails and additional information. We thank again Paul Jordan and Josh Schroeder of Sneed, Vine and Perry. The oldest, as Josh said, the oldest law firm in all of Georgetown or Williamson County. Josh, my notes.
Texas.
Central Texas. Amazing. Thank y'all
for the whole time.
Same building that y'all were many years ago too, located on the Georgetown Square. Thank y'all for what y'all do. Thank you for both of y'all's community service. Josh, thanks for serving on the Chamber board as well. Guys, have a wonderful day. Stay safe, and let the Chamber know if we can do anything more for you. Have a wonderful day.